The gavel falls. The child leaves the courtroom. The heavy wooden doors swing shut, and the case file is officially closed. But for the legal professionals left sitting in the quiet of the room, the case is rarely over, because deep down, there is often a lingering, quiet realization that something went terribly wrong. If you work 60 hours a week until you can no longer function, your battery is simply empty. That is burnout. But the trauma of family law is often deeper. It is the internal friction of a compass needle violently shaking as it's forced away from true north. When a legal professional is required to follow a process they know will harm a child, it creates a psychological wound called moral injury. To understand how this happens, picture a massive ship taking on water. On the upper deck, panicked parents are holding tight to their children. The situation is dire, and everyone can see it. Down below, the people responsible for navigation aren't rushing to the lifeboats. Instead, they are stuck holding committee meetings. They are carefully debating internal policies, drafting lengthy reports, and meticulously filing thousands of handwritten pages into endless rows of metal shelves. Eventually, someone below deck asks the obvious question, why aren't we up there helping the children? And the answer comes back, because that isn't the process. That exact moment is where the injury begins. Almost everyone enters family law believing that families deserve support and truth matters. Then the reality of the system arrives. They discover that clearing massive caseloads, hitting statistical targets, and navigating political optics take priority over actual human outcomes. This collision creates the "I knew better" injury. Professional will look at a family, see the clear warning signs that a child is in danger, and realize they are completely blocked from acting because of strict procedural rules. Imagine walking down a sterile office hallway and smelling thick, dark smoke creeping under a door. You do exactly what you're told. You fill out the incident report and leave it on a desk. Then you stand there, helpless, watching the building burn to the ground. For a young attorney or social worker, this institutional betrayal proves that the daily mission has shifted away from protection and toward maintenance. To survive years of constant trauma and high conflict accusations, mid-career professionals build psychological armor. Empathy becomes a liability. To protect their own sanity, they develop a numbness injury, where families crying in the lobby barely register, and children are reduced to case numbers on a docket. Even with that armor, they still experience the witness injury. This is the specific helplessness of watching a case drag on for years while a child loses precious time with a loving parent. Everyone knows the child is suffering, but the procedural machinery keeps moving, as overwhelming and unstoppable as a high-speed train violently rushing past. When these professionals do see clear systemic failures, they quickly learn the cost of speaking up. Facing career retaliation, isolation, or the sudden loss of judicial favor, they swallow their objections. Every time they suppress the truth out of fear, they create another scar. The coping mechanisms designed to protect a professional's mind eventually block their capacity for compassion. Without realizing it, they become silent participants in the harm they set out to prevent. In the late stages of a career, this erosion leads to a state where following the rules becomes the only objective. Professionals stop asking if a child is safe and only ask if the proper forms were filed in the correct order. The map becomes more important than the child's actual destination. This sets the stage for an identity fracture. It happens the moment a professional looks at a ruling they just approved and asks, would I ever allow my own child to experience this? When the honest answer is no, their self-image as a protector shatters. After years of enduring identical patterns, high conflict delays, repeated allegations, the endless cycle of hearings, a deep sense of learned helplessness sets in. The professional stops believing that systemic change is possible. Reform dies the moment "this shouldn't happen" becomes "this is just how things are." In that shift, the professional accepts the dysfunction as the natural state of the world. Institutions, like the people inside them, naturally want to protect themselves. When massive problems arise, courts and legal organizations prioritize their own public legitimacy and credibility far above their accountability for broken families. Instead of asking, how do we fix this flaw? The immediate question becomes, how do we protect ourselves from the fallout? It is like taking a roller of fresh white paint and applying it directly over a spreading patch of dark mold. The wall might look clean on the surface, but the structure behind it is actively rotting. The family court system traps genuinely good people, judges, attorneys, and mediators, inside a machinery larger than themselves. They find themselves in a cycle of moral grief, forced to maintain a failing system because the process has become the only priority. Every family law professional can recenter their focus by applying 5 questions to every procedural decision. This is the child test. Will this increase safety? Will it strengthen healthy relationships, reduce conflict, increase accountability? And finally, if this were my own child, would I accept this outcome? If the answer to any of those questions is no, the procedural machinery needs to halt. The exact moment a professional proceeds despite that no is where moral injury takes root. Ultimately, the defining moment of a family law career isn't a dramatic trial or a landmark ruling from the bench. It is a quiet moment at the end of the day when a professional looks in the mirror. Staring back at their own reflection, they must answer one final question. Did I protect the process today, or did I protect the child? Children eventually grow up. The thick paper files are archived, and the courtrooms will eventually empty. But the memory of a system failing a vulnerable family doesn't simply fade away. Long after the paperwork is forgotten, the memory stays with the conscience.